All rise.
Thank you. You may be seated. King, you may proceed when you're ready.
Thank you, Your Honor. May it please the court, my name is Melissa Schlichting. I am an attorney for the Confederated Salish and Kootenai tribes, and I will be responding to objectors' arguments. In the interest of time, I will keep them brief and respond to those and try not to get into the arguments that were made yesterday. The compact parties, through their briefing and yesterday's oral argument, established that the compact is both procedurally and substantively fair, that it is reasonable and within the bounds of existing law. Objectors fail to show otherwise and establish no material injury that will occur by operation of the compact. Objectors' arguments fail for the following reasons. First, there is a compact. Objectors' arguments that changes made by the Montana Water Rights Protection Act required ratification by the state were addressed previously by co-counsel in response to objectors' Jocko and Mission irrigation districts, and were specifically refuted by the compact parties in our answer brief, docket 1898 at page 3, and our reply brief, docket 2044 at page 4. I'll not revisit those arguments except to say that both the Crow and Blackfeet Federal Settlement Acts also made changes and also contained similar execution statements to that attached to the Confederated Salish and Kootenai Tribes compact that was approved through the Montana Water Rights Protection Act. Objectors' other arguments pertaining to the Montana Water Rights Protection Act, that it created new or unknown water rights simply because it includes a reservation of federal and tribal claims under federal pollution laws, namely the Clean Water Act, Safe Drinking Water Act, and CERCLA, are unfounded. As explained in the compact parties' answer brief, docket 1898, pages 4 to 5, such retention clauses simply clarify what water rights claims are being settled and what others are being preserved. Both the Blackfeet and the Crow Federal Settlement Acts include very similar provisions. Next, objectors' arguments.
Ms. Schlichting, if I can just stop you there. I want to make sure I'm clear. The abstracts that are attached to the compact, and the compact does say that in the event of a conflict between the compact and the abstracts control. Do those abstracts represent the full quantity of water, full quantification that is being sought in this case? In other words, are there any other contingent rights that are sitting out there that are going to come in front of the court at some time before a final decree is issued? Or
no, Your Honor. As was stated yesterday and today by yourself, the water quality claims are separate and apart from the water rights claims. And that is all that is being considered in the compact and should be, and the only thing that is before the court. Next, objectors' arguments related to the Hellgate Treaty and other treaties are simply not relevant to the compact, this proceeding, or the court's limited scope of review. The compact parties responded to objectors' various treaty arguments in our answer brief, docket 1898 at pages 8 through 11, and again in our reply, docket 2044 at pages 5 through 6. Even so, the compact does not replace or displace other laws like treaties. There is no requirement that the compact do so. Recognition of the tribal water right in the compact is not a depredation. The compact is a settlement agreement between negotiated and entered into by 3 sovereigns to settle the tribe's water rights. It is not required to reference or include any separately existing treaty provisions. Furthermore, the purpose of this proceeding is not to explore any treaty-based depredation that the objectors wish to advance, and to the extent that such assertion has anything to do with material injury, objectors must first establish that the compact is unreasonable or contrary to applicable law, which they fail to do.
So one of the arguments that Mr. Congdon made was related to the Walton rights and how the Walton rights somehow are put in question by the compact. Can you address that?
As Your Honor referred to them yesterday, the Walton rights will be settled in the adjudication of 76L and LJ. There's no requirement that they be included in the tribal water right, and they certainly is not before the court right now.
And does the compact, if the court approves the compact and enters a final decree, will any Walton rights be extinguished?
No. Any Walton rights will be, to the extent that there are any, will be settled through the adjudication process. The compact doesn't settle anyone's rights other than the tribes. Objectors claim that the compact somehow interferes with their right to navigate under the Peace and Friendship Treaty and the 1842 Boundary Treaty. The compact parties refuted this argument in our answer brief, docket 1898 at pages 10 through 11. Objectors have no particular right to navigate under either of the treaties, and no such right is required to be a part of the compact. None of the provisions of the treaties cited by objectors are relevant to or are impacted by the compact, and objectors fail to establish otherwise. Again, the compact does not replace or displace other laws like the treaties. There is no legal requirement that the compact do so. Objectors seem to want the compact to globally encompass and settle any and all claims they may have against the tribes. But the compact only settles the tribes' water rights, no one else's. The compact's call provisions are legal. We addressed this argument in our answer brief, docket 1898, pages 11 through 12. The compact is a negotiated settlement. Neither state nor federal law requires the tribes subjugate any portion of their senior right to junior water users, or to do so in a manner that affects the most junior water user first. Even so, the tribes and the U.S. agreed in Article 3G of the compact to provide sweeping call protections to a large number of water users. Objectors' argument on this issue seems to surround objectors' general dissatisfaction that the tribes did not subjugate all of their senior water rights. That the compact does not do so does not make it unreasonable or unfair. Further,
if I can interrupt you, one of the arguments that was made was the parties who were not subject to the call protection proceedings. So the example was used of large ag users who could be called to preserve in-stream flows. If they are called, I think the argument Mr. Congdon was making is those senior users could then turn around and make calls on the small users who are protected from calls under the compact, but they're not protected from calls from the large users. Is he accurate in that statement?
Your Honor, I was just about to turn to that.
Okay.
It seems like objectors' complaints about junior water users being forced to exercise their water rights against other junior water rights holders or having to pay for a water commissioner is not really a complaint against the compact, but a complaint against the prior appropriation system.
Well, that may be true, but once the compact is, if the in-stream flow rights are quantified and are decreed, those become the most senior rights and the ones that have to be satisfied first. So that won't that change the landscape on the ground?
The in-stream flow rights benefit water rights holders because it keeps the water in the stream. They can make call to make sure that there's enough in-stream flow rights. But in the specific example of the Missoula Irrigation Water District, it's immediately downstream of a junior in-stream flow right, and it only benefits the district. So what also happens, those in-stream flow rights exist with and without the compact. They would have to be adjudicated, but they have been filed. What I think objectors fail to appreciate and comprehend is that in the absence of the compact, the tribes could exercise those same senior in-stream flow rights, and junior water rights users would have to exercise their rights under the prior appropriation system, including, if necessary, paying for a water commissioner and making call on their neighbors. The compact doesn't change that. Despite Objectors' arguments to the contrary, the compact provides an appropriate remedy for disputes through the UAMO and the Flathead Reservation Water Management Board with review by a court of competent jurisdiction. We addressed this argument at length both in our arguments yesterday as well as in our answer brief at docket 1898 pages 12 to 13 and our reply docket 2044 pages 6 through 8. The compact parties, I believe, sufficiently addressed those issues. As such, objectors' motion demonstrates no procedural or substantive unfairness with the compact, and moreover, objectors failed to meet their burden to show the compact is unreasonable or contrary to applicable law, and that material injury will occur by operation of the compact. Therefore, the court should deny their motion.
Okay, thank you. Mr. Congdon, any questions? And I do have one question for you that maybe I'll start out with.
Yes, Your Honor.
And the question is, Ms. Schwifting just alluded to this, so if the compact is not approved, do you know what happens in that situation?
I think two things happen. If the tribe decides to proceed with the claims it made, those will be adjudicated through the system.
Right, and if that happens, counsel made the point that there are in-stream flow claims that would have to be adjudicated by the court. Is that your understanding?
It is my understanding, and there's a whole myriad of interesting law about that, Your Honor.
And currently, under this settlement embodied in the compact, there are certain water users who are protected from calls. Is that your understanding?
No.
No water users are protected from calls?
They are not, Your Honor, because if...
Calls from
the tribe.
The tribe, okay.
But not protected from call, because I will still call them when I have to, someone was irrigation, etc.
Right, but my question is, currently there are some call protection provisions embodied in the compact. Is that right?
Yeah, there are two.
And I guess what I'm wondering is, if the court does not approve the compact, what happens to those call protection provisions?
They are not implemented that same route. It will be first in time, first in line, the way the call system is today, without regard to source, without regards to volume, and without regard to use.
Okay, so and the subordination would be eliminated, right?
Right. First in time, first in line will be the rule still that we have now.
Okay. Thank you.
Yes. Okay, so a couple of notes. What Melissa said at the beginning as well, the water quality claims, they're just about what rights are basically settled, what water right claims are settled, and what water right claims are reserved. That was her sentence. What water rights claims are settled, what water rights claims are reserved. Not water quality claims, what water rights claims are settled. That is how she worded it. So the truth is, our concern about it's a water right for water quality is a legitimate concern, because her own admission right there is saying all that language does is talk about what water rights claims we're reserving, not what ones are settled. Well, our point is, if it's a water rights claim, the compact is not doing what it's supposed to do, which is finally resolve all the existing claims of the tribe.
What would be the process that such a claim would come before the water court?
That would be, I would have two thoughts, Your Honor. Under state law, I think it needs to go to the water court as a claim.
Right, but how would that happen mechanically? Because the period for filing claims, even for tribal reserved rights, is now passed. So what would be the process to get that in front of the water court?
I think it would be a petition to the water court to acknowledge the claim, and I think the compact language that says they weren't abandoned, that they can't be abandoned if they're a tribal claim, would say the court does retain its jurisdiction regarding a new claim, not with a new priority date, with the existing old priority date on that claim would be part of the legal argument. I do not have a mechanism, Your Honor, past that, except the other thought would be, does the federal government get a court of claims claim for the water quality claim that goes to them, and the court of claims then says this water right comes out of the pool of whichever water, or finds it that way. I don't know if it can be done by a court decree from that court to this court to try to say, is there a water right? I do not have a clear mechanism to get there, but the concern is the temperature thing is a very real issue. for fish everywhere because we've done away with the return flow. So that being the case, it's something that I find stressing, that she acknowledges there are water rights claims that are waived versus water rights claims which are not, but they are water rights claims. That's our concern. In respect to your Walton issue, Your Honor, the Walton claims need to be part of the tribal water right we submitted because they were done on the reservation for those purposes of the treaty, and they should come off that. And if they don't come off that right, or not a part of that date and that amount, they then are a double dip. A piece of allotted land on the reservation that got a water right to be farmed for 80 acres got 10 minus inches of water. If that doesn't come off of the tribal water right, the tribal land on the reservation gets that 10 inches, but still has the whole tribal water right intact, although the allotment was a purpose of the treaty, and that should have been part of the tribal water right that was specified that was reserved. So the concern is, by not addressing the question of does the Walton claim be included into those rights, be included in the tribal water right, the amount of water, it's allowing a double dip or a triple dip or a quintuple dip. And that is the issue we have with that.
And does that issue exist with other compacts that the court has already approved?
I have not seen it with one else because I think the reason it doesn't exist is this is the reservation that was affected most by an allotment provision on its treaty. The others do not have that anywhere. And two, as far as I know, none of the other reservations were opened by the 1904 Act the way this one was.
But do you know if Walton rights exist on other reservations?
To my knowledge, they don't, except at Rocky Boy.
All right. And if that's not accurate, would that change your position?
That they do exist elsewhere?
Like the Crow Reservation or the Blackfeet or the Fort Peck or the Fort Belknap? Do you know whether they exist for Northern Cheyenne?
I know they don't on Fort Belknap, etc., but I would say that they would not change my position. They should come off the water right of the tribe. They should be part of the tribal water right of that volume. The other problem is our settlement was after the treaty. So many of the other ones, the settlement was before there was a treaty. So there's that other question. Can it be a Walton right if the homestead was there before the treaty was done? Probably not. So I don't really have a good answer, except my concern was, is this compact fair, adequate, and reasonable in respect to that question? And I just think a double dip is what the problem is that we're having with the question. It should be included with a good priority date because there are Walton claims bought from a tribal member or their successor who sold it years ago. That was the reason. So the other change you'd asked me about was, the other note I made to myself was, the compact also says, nothing in the compact is construed to do anything to waive sovereign immunity by the state or the tribe, which is true. But the Treaty of Peace and Friendship says, in the event a depredation is not made good by the person, this is in our brief, lo and behold, the tribe has to satisfy the depredation claim in its tribal capacity. So the treaty waives sovereign immunity in 1855. And the compact should not get to change that. And so our concern is if the compact does that, that is why the compact is not fair, reasonable, or adequate, because it does something that wasn't even contemplated probably by the people drafting it. And I'll bet most of them had never read any of the treaties. That's my guess for the most part. But I hope that answers your question.
Thank you, it does.
Thank you.
All right. That concludes this motion, or this set of arguments on motions, and we have one more to go, and that would be the, I believe it's going to be either Mr. Tchida or Mr. Marche.
I drew the short straw, so I'm going to go for it.
All right.
That was the winning straw. Good morning, Judge Brown. Your Honor, my name is Rick Shoening, and I'm going to spell it for the record, S-C-H-O-E-N-I-N-G. I'm a pro se objector to this water compact. I reside in Basin 76L. I live on a tract of homesteaded land that lies within the exterior boundaries of the Flathead Indian Reservation. I have resided here for nearly 40 years. This is my home. According to my land patent, granted through several acts of the United States Congress, I have the patented right to use the water from the Flathead Reclamation Project as an appurtenance to the irrigable lands. I pay for this right every year through my real estate taxes. Your Honor, several objections have been presented in affidavits of disputed facts in this case over the last few days, well, yesterday and today. And so in the interest of time, I'm going to go through these disputed facts that the objectors have. So in docket number 1916, docket number 2037, and docket number 2055, we have presented many facts that are on dispute contained in the compact in the parties' briefs. I'm going to speak to address docket 1788, filed by me on behalf of many objectors who have similar views, and that is the right to a jury trial or an adversary jury to be the fact finders in the case. So this is a matter of both procedural and substantive due process, I hope the court will admit. I also submit some of these are a mixture of both law and fact. So I submit the following for your consideration. It is clear from yesterday that the events, even the contents and the provisions of the Hellgate Treaty are in dispute. Who created the reservation and for what purpose? Parties say it did, and its purpose was to create a permanent homeland. Well, the objectors deny this. Number two, the parties state that they have off-reservation water rights due to Aboriginal occupancy and ownership in vast lands in eastern Montana. One of the reasons of the main purpose of this compact is to avert the thousands of claims of water rights to these vast lands. The objectors deny the claim of ownership and state it has to be factually determined who claimed much of eastern Montana. The Lame Bull Treaty of 1855 and the Fort Laramie Treaty of 1851, where 21 chiefs signed these treaties, helped establish much of this territory of these vast lands. In fact, Lame Bull Treaty was to expire in 99 years, 1954. The Salish, Kootenai, and Ponderay did not attend the Laramie Treaty. The Salish, Kootenai, and Ponderay tribes did attend the Lame Bull Treaty and were recognized as Western tribes.
So I guess the question I have is, what are the factual issues? I'm trying to distinguish in my mind the difference between...
I'm almost there, Your Honor.
Well, if I can finish my question.
Yeah, sure.
An interpretation of a treaty versus a factual dispute about what is the language of the treaty. Because as I understand your motion, you're asking for the court to order a jury trial and putting aside for a moment what the court even can have a jury trial on. My question really is, what are you asking a jury to decide?
Are the facts. So for this particular situation, the Western tribes were allowed to hunt in Blackfeet territory. So what we're questioning is, the parties say first in time, first in right. Well, it's actually last in time and first in right. So that was another one, okay? So, number three, what does Article 1 of the Hellgate Treaty mean and say under ordinary understanding? We are told the Confederated tribes of Indians hereby ceded, relinquished, and conveyed to the United States all their right, title, and interest to, and conveyed to in the country occupied or claimed by them bounded. So, any off-reservation claims to any lands described in Article 1 that were ceded to the United States would not have any tribal water right to any land off the reservation. And parties say yes, yes they do. Objectors, we say no. And the court case of Naaman gave us guidance on that with what the word ceded means. And that case is in our table of authorities in our motion of July 10th.
You do agree that those are the words, though, right? There's no dispute that there are other words out there, that those are the words of the treaty. Do you agree with that?
Yeah.
Okay, and so isn't that a question that the court has to answer in terms of what those words mean? It's not a question of what the words are, it's what the words mean.
I guess what the words mean, the facts of what does seated mean. That's what we're asking. Okay. So then as number 4, as per Article 3 of the compact, will maintain in-stream flow, as discussed yesterday, impact irrigators for their crops and cattle. So in other words, does the right of fish to have more priority to cattle and crops, and can both be satisfied? That's a question, a fact. Number 5, the language of Article 2 of the Hellgate Treaty is in dispute. Clearly, the language states the reserved land was to be surveyed and marked out. Well, what does that mean? This is a white man language for describing not communal tribal land, but individual landholders. This supports the idea of the purpose of the reservation was to create landowners, homes, and not permanent homeland. So the parties deny this. Well, that was another one. We need facts. Number 6, what does Article 3 of the Hellgate Treaty mean when it states the right of taking fish at all common and accustomed places in common with the citizens of the territory? Parties state that gives them the right to maintain a fishery, including off-reservation. We deny this and say that the plain language states this flat out, was to give both Indian and non-citizens the right to fish as we do today. We notice the parties, in their zeal to maintain off-reservation water rights for fishing, do not mention the right to gather roots, berries, pasture horses and cattle, and hunt in common on open and unclaimed land. No, they don't mention that. Number 7, we have argued in our brief that there is fraud, collusion, and overreach in this compact. This is one of the criteria in determining the fairness of the compact. We have specious terms such as tribal water right, which assumes a communal water right. The Indian has an inalienable right to pursue water in any individual as per Article 2, Section 3, for life's basic necessity. The parties maintain is a communal right. The objector says, we say it's an individual right. So there's a fact that needs to be determined. Then, as stated earlier, permanent homes was the intent of Congress when they ratified the Hellgate Treaty in 1859. This is clearly indicated by Article 6 of the treaty, and we will locate, it says, quote, locate on the same as a permanent home, unquote. In the 6th article of the Omaha Treaty, which also states, quote, permanent home, unquote. Courts have continually got this wrong. In fact, in their reply to the assertion of permanent homes, the parties say there is no case law on that. That's son of a gun, no case law. Imagine that. The treaty does not speak of a permanent homeland. This is false. The tribe's own Flathead Reservation timeline admits the purpose of the Allotment Act of 1904 was to break up of the communal tribal lands, which was the intent of the Hellgate Treaty. Yesterday, we heard the case of Adair, 1983 mentioned. What is also significant is the court stated in Klamath tribe had lived in Central Oregon and Northern California for more than 1,000 years. It provided no documentation for this assertion. Furthermore, it is referred to this as a permanent homeland. This is not analogous to this case, as the purpose of the Hellgate Treaty was not to create a permanent homeland. So that's another one. Number 9, there are specious terms and vague terms used in definitions of the compact. Parties say no, objectors say yes. Examples are court of competent jurisdiction, which as shown yesterday is clearly confusing and vague as to its implementation. Another example is Article 2, number 33, where the compact defines the Flathead Reservation, which refers to all land. This is false, for most of the land within the reservation is privately owned, mine included. Homestead Act, Claremont case, back in 1908, in the Indian title that is given up, is that property is no longer part of the reservation. Number 10, the tribes have provided no historical documentation for their assertion of lands in eastern Montana and their dependency on fishing. They make their assertions, but no documentation. So let them bring documentation in an evidentiary hearing. And as number 11, who administers the Walton right on the reservation? You've heard that discussed. The compact states that the Water Management Board has exclusive jurisdiction to interpret the provisions of the compact. See Article 4, number 1. So they will interpret how to administer a Walton right as to senior status or abandon the right. It'll be up to that Water Management Board. Is that true? On the reservation? Number 12, did the legislature actually give informed consent? 13, do non-tribal members who reside within a reservation live under different rules? This is historically false. Settlers did not understand different rules when they bought surplus land on purchase of allotted lands. So, Your Honor, those are some of the disputed facts that I believe that need to be done in front of a jury. And so I'm just going to give you a little history there on, according to the Water Court Adjudication Rules, number 20, no right to a jury trial exists, as you well know. This is an incredible denial of due process. There's no legislative history to indicate the adoption of this rule. No explanation is given as to its origin or the reason why a jury trial is denied. Nor does this inform anyone as to whether the water court is a court of equity, therefore a jury not being allowed. This particular case is a mixture of law, factual matters, and property rights. The right to a jury trial is one of the most time-honored inheritance of the Magna Carta of the United States. It refers to the guarantee that courts will depend on a body of citizens to render judgments in most civil and criminal cases. Because the whole idea was to have the authority given to men whose peers were the individual on the trial, not the baron or the king. 18th century Americans viewed that right to a jury trial as one of the essential liberties of a free country. They saw the jury as an independent and deliberate body that could refuse to cooperate with an unjust court or law. Although the United States Constitution recognizes a right to jury trial in criminal cases, the states demanded a constitutional amendment to guarantee a jury trial in civil cases as well, leading to the creation of the Seventh Amendment. Now, I'll quote that. Let me get a drink, please. You guys are all attorneys, you know this stuff, but I'm quoting it on for the record. Seventh Amendment, quote, in suits at common law where the value and controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States according to the rules of common law. A jury trial is really a check against government overreach. And the founders were wary of a very powerful central government and sought the abuse of power. Sorry about that. So, a jury trial was seen as a crucial check against potential government overreach and unjust prosecution. The thinking was that a group of peers, unlike biased judges or corrupt government officials, like I said, could provide a balanced and impartial assessment of the evidence, and that common citizens would uphold the community standards and protect against tyrannical government actions. So the whole idea of the Sixth Amendment, it guaranteed public trials, is to promote transparency in the legal process and to ensure that justice was administered openly, fostering public confidence in the legal system. You know, it was included as part of the Bill of Rights. And it's seen by many judges, as well as plaintiff and defense attorneys, as providing a fairer way to resolve lawsuits other than bench trials or arbitration. Let the jury decide. The U.S. Constitution is the supreme law of the land. The Sixth and Seventh Amendment guarantees the right to a jury trial. The Montana Constitution clearly states in Article 2, Declaration of Rights, Section 26, trial by jury. The right of trial by jury is secured to all and shall remain inviolate. Is this not a civil action? This is, isn't it? The Montana legislature has also authorized the right to a jury. Water court proceedings are governed by Title 25, the Rules of Civil Procedure under Chapter 20. In Section 6, Rule 38, it states, right preserved. The right of trial by jury as declared by the Montana Constitution or as provided by a Montana statute, quote, is preserved to parties inviolate, unquote. You know, actually the act of denying my rights to a jury trial could be described as a judicial taking. So the court made a statement a while back, I think it was an October 10 meeting, that the facts are already known. Well, many of the statements that I brought up earlier, I believe, say differently. So, John Adams said in 1774 in the Bill of Rights, the right to a jury trial, along with a representative government, serve as the heart and lungs of liberty. According to John Adams, without them, we have no fortification against being ridden like horses, placed like sheep, worked like cattle, and fed and clothed like swine and hounds, he said. What a guy. The long and short of it, Your Honor, is that the Founding Fathers included jury trials in the Constitution because jury trials prevent tyranny. The definition of tyranny, of course, is oppressive power exerted by the government. And the compact parties are the government here. Jury trials are the opposite of tyranny because the citizens on the jury are given the absolute power to make the final decision. The court must remember that we are all equal before the law. There will be a hearing for these matters scheduled for January 6, 2025, I hope. The factual matters pertaining to these issues of fraud, collusion, and overreach, and material injuries to the rights of the objectors should be determined by a jury trial. At the very least, if a jury trial is again denied, an advisory jury must be appointed. I pray the court will accept my objection and deny the compact party's motion to dismiss all objectors. Thank you very much.
Thank you, sir. I'm not exactly clear on what, are there other parties arguing other motions? I mean, I appreciate yours, and
I guess, yeah, you're
what I'm trying to figure out is, I was somewhat, I accepted the filing that you all made in terms of the motions you identified that you wanted to argue. You've now argued one of them. I guess what I'm wondering is, are there other parties arguing other motions, and what exactly is the scope of what we're doing? Partly because the procedure we're following is the compact parties have the ability to respond, and whether we want to wait until you're all finished or do it one by one. But I guess I'd like to know what else you have.
Well, that's up to you, Your Honor.
Well, that is up to me, but what I don't know is what else you have planned.
I know there was going to be, I think, 4 other presenters besides myself.
All right.
On different topics. I'm the one that wants a jury trial.
Understood. Who are the 4 other presenters, and what are they presenting on? And if they...
well, Rick Jore, Paul Marche, Mr. Regier, and... what is it? And Tchida.
And those are only on the motions that were identified in the filing?
That is correct, to my knowledge, yes. Oh, one hour.
All right. So, the order that I issued identified the motions that you identified in your filing. That's the motions that I'm assuming are going to be argued. So, it looks to me like you have identified more parties than you have motions identified. I'm just trying to figure out.
Possible, Your Honor, yes.
Okay.
We just
What is-
invested on that.
Sure. I guess I'd like somebody to tell me what order and which motions are going to be argued, because I want to be sensitive to time. I
Right,
also want to allow the compact parties the ability to respond either one by one, which is, I'm reluctant to do that. I would prefer to do it, have you argue all your motions, and then have the compact parties respond. But I need to know what's going to be argued.
yeah. Well, Your Honor, I would say that's your call, as far as letting them argue at the end, or, I believe the fellow objectors that are waiting to talk would most likely rather have a rebuttal afterwards. I'll do it all at once, I believe, if you would allow me.
All right, so I'll do it this way then. The next motion that was identified is 1832, which is a motion on fairness and adequacy that was filed by the Jores, Mooches, Dennison. Who's arguing that motion?
With Rick Jore, I believe.
All right. So before Mr. Jore, you come up, from the compact party's perspective, my inclination is to just do this as a package and then do one rebuttal. Is any objection to that process?
That's fine.
All right. I think it's more efficient. All right, Mr. Jore, you may argue 1832.
Thank you again, Robert.
Thank you, Judge Brown. I appreciate the opportunity to offer my remarks. My emphasis, intended emphasis will be to affirm my arguments pertaining to equal protection. But I would like to touch on an issue that was addressed yesterday and to confirm my support for that.
And before you get started, I just want to let you know that your briefing is very extensive. I certainly am aware of your briefing, and I want you to make the points you need to make, but you don't need to reiterate things that are already done in writing. But to the extent you need to explain anything or something that came up, you're certainly free to do that.
Okay, thank you. Rick Jore, I reside in Lake County. And have been a lifelong resident there and own property there and have state-based water rights. The Siegel-Slack objectors addressed the separation of powers issue, which we touch on in our motion, and I would just like to concur with their arguments, but also, I think, add something that I think makes the point. They did mention the fact that there apparently is some confusion even among the board regarding what it is to be called, even to the point that they hired a law firm to help define their title and their role. And the law firm concluded that the board is neither a state nor tribal government entity. And so from my perspective, that right there, not being a state entity, would be a clear violation of the separation of powers language in Article 3, Section 1, that requires that all government in Montana is included in either the executive, legislative, or judicial branches. And the conclusion of that memorandum was that this board is a governmental instrumentality, but it didn't indicate which government or which branch. So I wanted to make that point regarding the equal protection argument yesterday. regarding equal protection, I would like to point out, and for the record, Judge, that it seems to me that the chairman of the Reserve Water Rights Compact Commission, when he stated what he called the grand bargain, agreed with our position that in fact non-tribal member Montana citizens are being removed from the jurisdiction and control of the state regarding water rights administration per Article 9, Section 3. That grand bargain statement from Chairman Chris Tweeten was this: the response is to remind the tribes about the grand bargain and the fact that we agreed to do this extraordinary thing, frankly, with respect to agreeing to subject or to remove non-Indian rights on the reservation from the jurisdiction and control of the state and place that somewhere else at the tribe's request. So in my view, Mr. Tweeten's words are unequivocal. The commission intended to and agreed to remove citizens, tax-paying Montana citizens, from the benefits and protections of the Montana Constitution, and pertaining specifically to their water rights. Much of the compacting parties' opposition or response to our equal protection argument rested on the notion that non-tribal citizens within the boundaries of the reservation are not similarly situated with other citizens of the state of Montana outside the reservation. My contention is that that comes from an issue that's much discussed on the compact, and it certainly was yesterday, and that is about the purpose and intention of the Hellgate Treaty and the purpose of the reservation. And I would like to read language directly from the Hellgate Treaty that was not has not been entered into the record. Article 2 of the treaty said, there is, however, reserved from the lands above ceding for the use and occupation of said confederated tribes, and as a general Indian reservation, upon which may be placed other friendly tribes and bands of Indians of the territory of Washington. So that language seems clearly to me to speak of the notion of assimilation document rather than a permanent homeland document. If as a general Indian reservation, and other tribes could have been placed here, any number of other tribes. Article 5 of the treaty has language that seems to indicate an assimilation intent also. It establishes an agricultural industrial school, one blacksmith shop. I'm reading just parts of it here, so not to extend the time. A carpenter shop, one wagon and plow maker shop, employ two farmers, one blacksmith, one tinsmith, one gunsmith, one carpenter, one wagon and plow maker for the instruction of the Indians in trades and to assist them in the same. And that, specific to the treaty, was for a period of 20 years. In my mind, that conveys an assimilation concept rather than a permanent homeland concept. Article 6 has been mentioned, but I'd like to read directly from Article 6 pertaining to the homeland language. The president may from time to time at his discretion cause the whole or such portion of such reservation as he may think proper to be surveyed into lots and assign the same to such individuals or families of the said confederated tribes as are willing to avail themselves of the privilege and will locate on the same as a permanent home. So the use of the permanent home language, in my view here, is in the context of permanent homes for individual Indian families rather than as a communal homeland concept. And then, of course, has been mentioned, Article 6 of the treaty goes on insofar as establishing the process of allotment and what would take place after allotment, and that is Article 6. You have to go to the Omaha Treaty, because the Hellgate Treaty references that on the same regulations as are provided in the 6th article of the treaty with the Omahas, and that many times the rest of that is not printed because that's where the Hellgate Treaty ends. But to get the whole of Article 6, the Omaha Treaty says, in part, and the residue of the land hereby reserved after all of the Indian persons or families shall have been assigned to them permanent homes may be sold for their benefit under such laws, rules, and regulations as may hereafter be prescribed by the Congress or President of the United States. And then, of course, historically, from that authority in Article 6, eventually arose the Flathead Allotment Act of 1904, an act for the survey and allotment of lands now embraced within the limits of the Flathead Indian Reservation in the state of Montana, and the sale and disposal of all surplus lands after allotment. Now, regarding the notion of whether we often hear in this testimony a reference that I may live on the reservation, and that presupposes a non-diminishment, I guess, of the reservation. I'm not comfortable with that language because I don't think it legally expresses the fact that I actually live on private land that by this language would have been removed from reservation status. And even in 1934, in the Indian Reorganization Act, I think it's important to point out that even though that act was a 180-degree about face by the federal government in Indian policy, it still protected and recognized the fact of these lands that were withdrawn from the reservation. If I could read that, the Indian Reorganization Act of 1934, be it enacted that hereafter no land of any Indian reservation shall be allotted in severalty to any Indian. And then Article 3, that's from the title, Section 3 of that act, which I want to emphasize, the Secretary of Interior is hereby authorized to restore to tribal ownership. Interesting that they had to use the word restore because it had been removed, so it had to be restored. The remaining surplus lands of any Indian reservation heretofore opened, provided, however, that valid rights or claims of any persons to any land so withdrawn shall not be affected by this act. So it seems to me by the plain language there that private property, valid claims of land that had been sold to non-Indians was recognized to be withdrawn from the reservation, which brings me to why I oppose the definition of Flathead Reservation in the compact, which is all land within the exterior boundaries of the Indian Reservation established under July 6, 1855 Treaty of Hellgate, notwithstanding the issuance of any patent and including rights of way running through the reservation. That doesn't recognize private property. Now, interestingly, in my view, the Enabling Act of 1889 that authorized statehood for Montana had language that was incorporated into Article 1 of the Montana Constitution, which says, all lands owned or held by any Indian or Indian tribes shall remain under the absolute jurisdiction in Congress of the United States. I think the state is entirely double-minded and inconsistent when they accept the definition of the Flathead Indian Reservation, which assumes that private property is still reservation land, but they still assume to exercise jurisdiction over that land and to tax it. I would place, quite frankly, more credibility and merit in the arguments of the compacting parties if they were to contend that, in fact, the state of Montana has no jurisdiction within the boundaries of the reservation, and that, I think, is what creates the conflict for the most part. I need to conclude, Judge, so I'd just like to mention, I know the court relies on the concept of case law, and I'll mention one case, and that's Claremont versus the United States, which was decided a few years after the Allotment Act, and Henry Claremont was charged with the crime of importing alcohol into the reservation, and he was arrested in Ravalli on the train. And when that case went to the United States Supreme Court, and they overturned the lower courts by stating that Henry Claremont was not guilty because he was not on the reservation, and that tribal title to the right-of-way, the railroad right-of-way, had been extinguished. That's Claremont versus the United States. It seems to me that consistency would require that same application, because it's, I think, the basis for our equal rights protection violation, and by assuming that we are residents of a permanent homeland of the CSKT. I can't make sense of that in a legal fashion. I am a resident of the state of Montana in Lake County, a political subdivision of that state, and that's where laws are applied to me and where I pay taxes. And my contention is that my representation in the government to which I pay taxes is not to be diminished without an equal protection violation. Thank you, sir.
Thank you, Mr. Jore. Appreciate your argument. The next one I have on my list is the due process procedure motion at 1799, I believe. Mr. Regier, or?
I'm arguing under the same issue.
Are you each making the same argument on the same motion?
No.
Are you arguing different aspects of that motion?
Yes.
All right. If you could identify yourself and which aspect you will be arguing.
I will be discussing the overreach within the compact.
And for the record, your name is?
My name is Katie French, and I want to thank the court for recently recognizing me as a co-objector with my husband, Mark French, who was unable to make the proceedings today. I am here wearing several hats. I, as mentioned earlier, am a board member with the Paradise Water District. I also am a owner on property that is within the Paradise District, and so we are concerned about access to water during the call situations. Third, I am a party to the ranch. This ranch enjoys a water right from 1895, which has secured our opportunities to raise ranching activities and animals over the course of several generations. I enjoyed the conversation yesterday in the court regarding an issue with a water user on reservation that affects the water user off reservation, we are that party. We are the first ranch downstream from the boundary of the reservation on Flathead River. So we are 76L. We are the first water right over 100 gallons per minute. And as I mentioned, we have senior water rights up to 1895. So as was mentioned earlier, not only are we going to have time-sensitive issues if we have to bring something before federal court because we can't go to state court, but also I have neighbors that are junior water right owners to me, and I'm going to be put in the responsibility and in the position of having to call on them because of something that happened upstream. It puts us in a very, very difficult situation, and I think that is a material injury. The other position I wanted to talk about is not just a private one, but also a very public one. As I said, I have neighbors and the community at large, and when we have constitutional issues that are diminished, it affects all of us, and we believe that that is one of the things that we need to stand up for. One of the criteria for review for this compact was fraud, collusion, and overreach. And I'll focus my comments on overreach. Recognizing that we are short of time, I'm going to condense my comments, but I wanted to focus on the position that the right of taking fish at all usual and accustomed places in common with the citizens of the territory, which is listed in Article 3 of the Hellgate Treaty, is another example of overreach. How does the tribe and other compacting parties confer a right of the water or an assent or assert a right to hold water rights by the tribe of off-reservation locales through fish? This, I believe, is an overreach. The presence or continued presence of fish in, quote, usual and accustomed places, unquote, is a mandate, a directive, a commitment by the territorial government that is in common with the citizens of the territory to ensure access, availability, and the right to procurement of those fish. That mandate has been kept. This mandate continues to be effectuated through the Montana Department of Fish and Game. The compact inappropriately equates the good management of fisheries activities as a cudgel to control off-reservation water rights. As presented in our oral arguments yesterday, the 4 court cases referenced by the compact parties agreed that the water bodies supporting the fisheries in question should be appropriately maintained, but the opinion of the court did not assert or confer water rights should be granted to the tribal entities in these cases. And they should not. The tribe's authority should not be expanded beyond its external boundaries through a treaty right of fishing procurement. I ask the court to recognize that the fishery activity in whatever locale becomes a water body issue, a basin issue, a watershed issue, which grows into a regional issue. This is the role of the state and should remain so. Is there a water right associated with in-stream activity? Yes, I believe there is, but I believe that that right belongs with the state and not with the tribe. To expand the tribe's authority incrementally outside the reservation boundaries portends an overreaching authority that the legislature did not consider, acknowledge, or intend. The uniqueness of the creation of the Water Reservation Management Board is another example of overreach. No other compact dealing with tribes in Montana has such a board. The overreaching powers of this board is enumerated in Article 5, Section 1-5. I have been, as I've stated earlier, not only is this board unconstitutional, it's also an example of overreach by the Montana legislature. The compacting party said more than once in their arguments yesterday that the uniqueness of the Flathead Reservation required the construction of such a board. This does not answer the unconstitutionality of its authority, and this does not answer the unconstitutionality of its reach. How is this board to set policy and establish strategic direction? What government body will this board report to? Will the actions of this board be public? What authority will the board have to limit transparency? The creation of a new instrumentality in and of itself has huge implications, and its growing pains and jurisdictional profile should not be the overarching legal quagmire that disrupts its decision-making powers as an arbitrator of water management issues on the reservation. Certainly, it should not be the arbitrator of water management issues off the reservation. We are not told if limits are placed by members of the Water Board on an oath to uphold the state and U.S. Constitution. Such an oath limits the members, for the oath confirms that all procedures and decisions are constitutionally limited. Paradise Water Board and the Paradise Sewer Board recently had an issue that we had to take to court specific to this, because we need to know and we need to be assured that we have access to all public meetings, that all public meetings are noticed, and that all public meetings are open. Secondly, we also need to guarantee or have a guarantee that the public has a right to examine all documents at this Water Management Board. We are also not told that Montana law will be used as a precedent in board decision making. What an overreach. To deny the state's courts the non-Indians within the reservation is another violation of the Montana Constitution. And I think most of that has been discussed before the court. And I just want to stress that it is, what is in place now is not time sensitive, and as was discussed, that could have far-reaching damages to the state and the community at large, not to mention the resource that we're talking about. Let's see. And I think finally, the exclusive jurisdiction issue that the board enjoyed should be a frightening call to everyone. This means a specific board has the sole authority to hear or decide a particular type of case. No other entity can hear that case. This is disturbing. It's frightening. So if there's an issue between a sovereign nation and the United States, does this have to go before the board first before it goes anywhere else? And should that happen? Exactly what type of power does this exclusivity transfer and deny our current governments? And if they are the sole authority to hear this case, does it nullify an opportunity to seek remedy somewhere else? I ask the court to recognize that this frightening jurisdiction cannot stand. Clearly, this magnifies our claims of legal and legislative overreach. Thank you.
Thank you, Ms. French. Mr. Regier, are you going to?
Judge Brown, I am Keith Regier, that's R-E-G-I-E-R. My wife Jolene and I reside a mile northwest of Glacier High at Kalispell in the Flathead Valley. We have 20 acres with a small irrigation well, as well as a domestic well. I'm also a state senator from Senate District 3. It was in the 2021 session when Senate Resolution 12 came through. And that was a confirmation of you to the Water Court by the Chief Justice Supreme Court. In that hearing, you said a few things that really important. You said it was an enormous privilege to be on the court, and that water rights are constitutionally protected. And you also said, quote, the things we do affect people for 100 years. And I take that very seriously, end of quote. Here's a serious job, and I appreciate what you do. Your testimony that day was very convincing. Senate Judiciary confirmed you 11-0, and then on the Senate floor you were confirmed 50-0. A lot of people counting on you. I was a House Majority Leader in the 2015 session when the CSKT Water Compact was passed, and there was an effort to manipulate the rules as well as ignore the rules to get that compact passed. I think the court has documentation of how that process and changing the rules went. Won't go into that with you, but I heard yesterday from one of the compacting parties that the court does not interject itself into the legislative process. That's really not true. In the last couple of years, the court has ordered the legislature to pay legal fees to a defendant, and in a case dealing with, I believe it was election laws. And more recently, the court ordered the Secretary of State
to poll the legislature on a Senate bill to see whether it should be vetoed. So, believe me, I'm not advocating that the court interject itself into the legislative process, but I just want to point out they have been selected in the past. Also want to share with you, Your Honor, how fear was used to get support for that compact. I was majority leader, had a lot of conversations with Republican representatives about that compact. Many of them from the east side of the divide stated that they would vote for the compact because the tribe would file claims in their district if it didn't pass. They wanted to save the expense and effort their constituents and having to go to court. They said the compact was a Western Montana issue and therefore they wouldn't vote, or they were going to vote for it. I asked them, had you read the bill? Did you see the things they're in? They really weren't that interested. They weren't concerned about issues in the bill. It was a Western Montana issue. Do I have documentation that that's why they voted for it? No. We don't poll legislators and have them write down why they vote or vote against something. We just have their record of yes or no. It didn't take many legislators to be coerced out of fear to vote for the compact, to get that compact passed, as it only passed by 3 votes. In my talk with legislators, there wasn't a single one that said, we don't want a compact. It was, we don't want this one. There are too many issues in there. Let's get a compact that's fair like the other compacts. Also in committee hearing, that would be in the House Judiciary Committee hearing on the compact, the sponsor and numerous proponents stated that amendments would kill the bill. You can't amend that bill. They said any amendment would have to go back to the tribe. That would mean it would be the death of that bill. Yet, as you heard Mr. Williams talk yesterday, the compact that came from Congress was amended. There's different things in there that wasn't passed by the legislature. That has not come back for legislative approval, as Mr. Williams pointed out yesterday. So was it not true that the legislature couldn't amend that bill? What if we would have been able to? Maybe it would have been a compact that would have been accepted by more people. Intimidation through fear and litigation is not letting the legislature improve a bill. It's not good legislative process, and it doesn't serve the people well. That's what I witnessed with the CSKT water compact. In my opinion, that compact would not have passed minus the fear factor. I want to thank you for putting up with a pro se objector, Jeff.
Thank you, Mr. Regier. Appreciate your comments. I think that brings us to Mr. Marche.
Your Honor, may it please the court, I'm pro se objector Paul Robert Marche. I have a private interest within the Flathead Reservation Water Basin 76L for irrigation and stock water. Today I'm requesting that the mediation as part of the hearing track be granted a formal hearing due to fraudulent and unprofessional nature of what took place on August 1st, 2023 in Ronan.
All right, so Mr. Marche, I'm struggling with this motion. I guess what I'm wondering is if there's anything you have to add that's not already in your briefing and your affidavit. And in saying that, I'm going to caution you that I am concerned about confidential information being disclosed in open court.
Yes.
And I want to see whether it's your intent to do that.
Can you repeat that?
Yeah, my question is, do you intend disclose information that would only be known to the parties within those mediation sessions?
I would be disclosing information that I think everybody saw or witnessed or heard that day.
Well, is it information beyond what's already in your affidavit? Because your affidavit does, I understand what your affidavit says. I haven't ruled on your motion yet.
Yes.
But I guess what I'm wondering is why your affidavit, or is your affidavit sufficient? Do you need to disclose anything further?
Well, there was a couple items, Your Honor. There were, I guess,
and I want to stop you, and I apologize for doing this, but I believe that...
I realize my motion is a little awkward.
It is, and it's unique to you, because you're the only one who's filed that motion. Nobody joined your motion. It's only your motion. And as I understand what you're doing is asking us to have a hearing on the mediation process because you were not comfortable with it.
Right.
All right.
And there were some legal issues that were also in my motion that I covered too.
Right, and I think it's well briefed, and I do intend to rule on it. But I am sensitive to the fact that there is a statute that prohibits disclosure of confidential information. It's also in a case management order that the court issued, and we do that for good reason. We want parties to be able to candidly discuss things in mediations and all mediations, and we have them all the time without the fear that by revealing confidential information in mediation it will somehow become public, because that chills the negotiation process. Now, I understand you may have some opinions about how this particular mediation was conducted, but I have to think about all mediations because we do dozens, if not hundreds, every year in the water court, and it's a very successful mechanism to resolve cases, but it's only successful because the parties have confidence that they can share confidential information without it being disclosed. So this may sound like a lecture, but I do not want confidential information disclosed in public. If you want to do a filing under seal, I would take that under consideration, but I'm going to ask you not to disclose any information learned during the mediation for the reasons I've just articulated. Is that?
Yes.
Okay, thank you.
And I do think that, I do question too that whether or not, confidentiality was breached during that mediation process. There was a point when we were told that we couldn't even talk to our neighbors about the mediation process, and then at some point that even changed, and we were told that we could converse with one another, and anything I said in that mediation was, everybody heard it. It wasn't truly confidential.
Okay.
So I think with that, Your Honor, I'll rest.
All right, and again, I appreciate your briefing, and I will take that under advisement and issue a ruling on that.
Thank you very much.
Mr. Tchida.
Your Honor, thank you very much for the opportunity to speak. I will be brief because a lot of the information that I was going to present has already been covered. My name is Brad Tchida, last name spelled T as in Tom, S-C-H-I-D-A. I am a resident of Missoula County. I have a well on my property, and I also have other water rights on that property as well. I'm not just here because of my own issue with the water compact, but again, general public interest requires that there be some comments made to protect the paramount importance of that public interest. I too was in the legislature in 2015 along with Mr. Regier, and there were a couple of things that he did mention that I would like to touch upon. First of all, we were not informed as a body how the compact negotiations had been conducted, such as who was involved, whether all meetings were open and recorded, were any intimidation tactics used, were all parties afforded an opportunity to participate. I too recall, as Senator Regier said, the intimidation and coercion that was conducted, because when we were told
by the parties that brought the bill to the legislature that if we did not pass this, and they were talking about we collectively, but obviously that collective we also includes the individual we, that there could be, and they used the number 10,000 water claims filed. So whether they filed them immediately or down the road, it would potentially impact somebody like me with a water right or other individuals in Montana. It's my belief that the compact violated Article 2, Section 17 of the Montana Constitution because we were told when we were discussing this matter that there were some areas of the western part of Montana that were excluded from the impact of the compact. I don't know for a fact whether that's the case. Having been in my first term and knowing that there's limited time to study things and that we rely on committees to hear what those proponents and opponents to certain measures are espousing, we have to rely on their understanding and their vote concerning that. And the bill was in fact not tabled in that committee, but it received what was called an adverse committee report. And the tabling of a bill falls under a different part of the rules of the legislature than an adverse committee report does. So the manner in which that bill was withdrawn from that committee and brought to the House floor was not done ethically or appropriately based upon our rules. And I understand that the court should not inject itself into those things, but it adds to the whole body that that bill fraudulently made its way to the House floor where there were discussions on it. And there were very few people that were required to side with the proponents to pass that piece of legislation. One of the points that was made, I believe it was by Mr. Jore, has to do with the fact that it could have been Mr. Shoening, that at the time of allotment in 1904, the plain language was that people who bought property on the reservation were buying property that would be privately owned. It was within the boundaries, but it was not part of the reservation. And I don't believe that anyone would have made that purchase had those requirements not existed at that point in time. I think it's important that the court consider the fact that intimidation and coercion were used during the legislative process. And you have two members of that legislative body who are here today that are stating those facts. And I believe that was the case because either through not providing the information or saying that by not voting for the compact, water claims could be submitted, or given the fact that we were told that there were, I want to make sure I have the statement here. I cannot find it in my notes here, but the fact that the negotiations were made in such a fashion that, well, I remember what it was, I'm sorry, Your Honor, that if the bill were amended by the legislature, there would be insufficient time during that session to be sent to the tribes for their approval and back to the legislature in 2015. But that basically says that a later legislative body would not have found favorably on that piece of legislation. So I think that it's important to understand that those of us who were there did not feel comfortable with the manner in which that compact was brought forward and the manner in which we were treated when we sought clarification on things. So I appreciate the time that the court has afforded.
Thank you, sir. Appreciate it. Would you like to respond on this process?
Your Honor, Rebecca Russ. The compact parties would request a break if that's acceptable, just to coordinate the response.
That is acceptable. Because this is the last thing that we have on the agenda, I really don't want to do a full hour lunch break, but if we take 15 minutes, is that sufficient?
That's fine.
Okay, and just so everybody is aware procedurally how we're going to do this, you will have your chance to do your response. this is being addressed just like all the other motions. So if there is rebuttal, it's rebuttal in response to what the compact parties have to say. But I would ask you to, if there is going to be rebuttal, to try to make it succinct. So if the parties could be mindful of that, because there is a lot of information in front of the court. We all run the risk of being repetitive if we prolong this. But we will take a 15-minute recess. Let's just come back at 12:30 and then we'll resume. So thank you.
All rise.
Recording stopped.